They hit Elon Musk with a $3.2 million fine, thinking he'd just pay and move on. But what he did in that courtroom left even the judge completely stunned. It was supposed to be a routine morning inside courtroom 7B of the federal courthouse in Fresno, California. Rain tapped softly against the windows. The clerk shuffled papers. Reporters, half bored, adjusted their cameras and sipped coffee from paper cups. Then the door opened and in walked Elon Musk, alone. No security detail, no legal entourage, just a gray suit, a dark tie, and an unreadable expression. People glanced, up curious but not shocked. Musk had been summoned for allegedly violating court protocol in a corporate litigation case involving one of his companies. According to the complaint, he had disclosed sealed details from the proceedings during a press event weeks prior. A clear breach of conduct, or so it seemed. Judge Deirdre Colton, known for her sharp, no-nonsense demeanor, presided that morning. She looked up, met Musk's eyes for a brief moment, then returned to her notes. "Elon Musk," she began. Her voice firm yet composed. "You have been found in violation of federal court orders relating to sealed testimony. The fine is $3.2 million payable within 14 days. No gasps, no dramatic pause. This was Elon Musk, a billionaire. A fine like that wouldn't rattle him, but something about the way he stood there, hands loosely folded, no reaction, no objection, caused a subtle shift in the room. Judge Colton leaned forward, perhaps expecting a response. "Do you understand the terms of the judgment?" "I do," Musk replied, his voice calm. "But I'd like to respond now." Heads turned. A few reporters straightened in their seats. He hadn't brought a lawyer, and yet he wanted to speak. For himself. Judge Colton raised an eyebrow. "Mr. Musk, I recommend legal representation before continuing." "With respect, Your Honor," he said, "I believe it's more appropriate that I handle this personally." She studied him for a moment, then gave a slow nod. "Proceed." And that's when everything changed. Musk reached into his jacket pocket and pulled out a single sheet of paper. No binder, no folder, just a single neatly folded page. He placed it on the table before him. "I'm not disputing what I said publicly," he began, "but I am disputing whether the gag order applied in the context in which it was used." Eyebrows lifted. "A legal gray area," he continued. "The order referenced in the contempt filing is tied to Section 35B of the protective hearing order issued on March 11th. However, subsection 35B3 allows for public safety exceptions under federal fair use laws, especially when the disclosed content pertains to stockholder impacting risks." Judge Colton blinked once. Reporters began typing furiously. "I only mentioned one aspect of a manufacturing process that, if misunderstood, could have posed a danger to consumers. I didn't name names. I didn't cite protected documents. I voiced concerns based on what I saw firsthand." The room grew still. A paralegal whispered to a colleague. Even the bailiff, who had been casually watching the door, now looked intrigued. Judge Colton narrowed her eyes. "Are you suggesting that you're protected under federal whistleblower statutes?" "I'm saying," Musk replied, "that the fine being imposed on me may contradict precedent set in Stansfield v. Verdi U.S. Tech Holdings, 9th Circuit, 2004. That case established that executive disclosures serving public interest cannot be penalized under seal protection if those statements fall outside the original scope of the gag order. A case, a ruling, a precedent. It wasn't bravado, it wasn't theatrics, it was precise, calculated, and now everyone in that room knew it." Judge Colton didn't like surprises in her courtroom, and Elon Musk had just rewritten the script. For a long moment, silence filled the room, just the faint hum of the overhead lights and the tapping of laptop keys. Then, finally, the judge spoke. "Elon," she said, her voice softer, less formal than before, "referencing precedent in this courtroom doesn't guarantee exemption. This isn't a theoretical argument. This is a federal penalty." But in that moment, it was clear. This was no longer a simple fine. And Musk wasn't just another defendant. Musk didn't flinch. "I'm aware," he said evenly. But it's not theoretical if the penalty itself contradicts its own framework. It wasn't just what he said. It was how he said it. Calm, measured, like he'd run through this argument 100 times, but not in front of a mirror. It came from something deeper. Not arrogance, not charm, just certainty. The atmosphere in the courtroom had shifted. The judge was no longer addressing a man accused of misconduct. She was debating someone who might actually know what he was talking about. Near the back, a reporter whispered, "Why didn't he bring his legal team?" Another murmured, "He must have wanted this to be personal, and maybe he had." Because by now it was. "Mr. Musk," Judge Colton said, her voice regaining its formal edge, "are you requesting a formal motion to dismiss the fine?" "No, Your Honor," he replied. "I'm requesting a reassessment based on statute 12-8-7F, Provision 4. The court's penalty exceeds the bounds of that statute in cases where sealed disclosure is nonspecific and intended to address imminent shareholder concerns." He paused. "I can provide precedent to support that." "Judge," Colton exhaled, "you're serious. I wouldn't be standing here if I weren't." Something about the way he said it was almost unsettling. Not disrespectful. Never that. Just unexpected. Like watching someone play a game they weren't supposed to understand, let alone win. She motioned to the clerk. "Bring me the transcript from the March 11th hearing and the full ruling from Stansfield v. U.S. Tech Holdings I wanted on my desk this afternoon." The clerk nodded and hurried out, leaving silence in his wake. "Elon," she said again, softer this time, like a parent trying to understand a child's logic. "Do you realize what you're doing? You're not just challenging a fine. You're questioning the limits of courtroom discretion." Musk met her gaze. "Yes, but with respect, Your Honor, if a court can issue unlimited fines for statements that don't fall under the exact wording of a gag order, where does that discretion end?" Behind him, a man from the Securities and Exchange Commission scribbled something in his legal pad. An attorney from a rival firm quietly slipped out his phone, typing under the table. This was no longer a contempt hearing. It was something else. A shift. A pivot. The kind of moment law students study years later, when a defendant didn't fight accusations with theatrics or high-powered lawyers, just logic. Musk stepped to the side table, picked up a printed copy of the March 11th order. 1. He had apparently brought himself and handed it to the judge. "Pages 3 and 4, he said. Third paragraph, you'll find the exception clause." Colton didn't look at him as she took the pages. Her eyes scanned the text. Her lips, pressed into a thin line. "This court has discretion," she murmured. "But even discretion," Musk replied, "has limits." No one spoke. Slowly, she looked up. Not with anger, not even annoyance. Something closer to realization. She didn't dismiss the fine. Not yet. But the certainty behind it had cracked. And if Musk had poked a hole in the dam, how far would the water go? By the time the courtroom reconvened after lunch, word had spread. Local journalists had already tweeted fragments of Musk's self-representation. National outlets were circling the courthouse. The hall outside 7B was packed with camera crews, legal analysts, and people who had never once cared about procedural statutes, suddenly asking, "Wait, could Elon actually win this?" Inside, the energy was tense. Not chaotic, just charged. Like everyone was holding their breath, waiting for a misstep, a stumble. Anything to prove he was just a tech billionaire playing pretend in a courtroom. But he didn't stumble. Musk sat at the same plain desk, hands folded, expression unreadable. He didn't check his phone, didn't look around, he just waited. Judge Colton returned, a yellow legal pad covered in notes. She didn't sit right away. "I read Stansfield twice," she said. "And I reviewed subsection 35B of the gag order." She glanced at him. "You were right about the exception clause." A murmur rippled through the gallery. "But," she continued, holding up the copy he had given her, "this exception only applies when the disclosure addresses a direct threat to consumer safety. Not speculation. Your statements in that press event suggested a potential risk, not a confirmed one." Musk nodded. "That's fair." Then quietly, But the statute doesn't require confirmation. It requires good faith. That's a legal standard, and the court can't punish good faith. Disclosures that fall within that framework remain valid, even if the concerns later prove to be overstated or non-lethal. Judge Colton studied him. "You're walking a tightrope, Mr. Musk." "I've walked narrower," he replied. A few chuckles escaped from the back row. Even Colton allowed herself the faintest hint of a smile, brief, almost involuntary, before returning to business. "I also reviewed your timeline," she continued, settling back into her seat. "You made your comments 2 hours after the hearing. Concluded. That suggests you spoke before receiving the full written order. Are you arguing that you didn't have access to the exact language?" Musk shook his head. "No, I had access, but the oral summary during the hearing was ambiguous. The clerk didn't send the full transcript until 6 hours later. By then, the press had already run with my statement." A hush settled over the courtroom. Colton leaned forward. "So you're telling this court that you take responsibility for the timing but not for the intent?" "Exactly," he said. "I was raising awareness of a pattern I believe poses long-term risks to shareholders. It wasn't about headlines or ego. And the data I referenced? It didn't come from classified documents, it came from our internal audits. That makes it mine." A young lawyer in the gallery whispered to a colleague. "He's pulling at every thread." "Yeah," the colleague murmured back. "And somehow, it's holding." Colton flipped through her notes. Then, with measured deliberation, she met his gaze. "You do realize this court isn't in the habit of being corrected by civilians." Musk didn't hesitate. "Then maybe that habit needs reviewing." The words landed like a stone dropped in still water. Bold, direct, but devoid of arrogance. He wasn't trying to win an argument. He was insisting on the truth no matter who said it. For a few long seconds no one spoke. The room wasn't frozen, just still. Like everyone had been nudged slightly off balance but didn't want to admit it. Colton exhaled slowly, her tone shifting. "You're forcing this court to consider precedent it hasn't applied in over a decade. I'm only asking the court to apply its own rules," he replied. Colton tapped her pen against the desk. Once, twice. "I'll take this under advisement. We'll reconvene in 24 hours for a final ruling. Until then, no further statements to the media. Understood?" "Understood." She stood, gathered her files, and left without another word. Musk remained, seated a moment longer, then quietly collected his papers and exited, not like a man who had won nor one who had lost. Just someone who had said what needed to be said. But as he stepped into the hallway and saw the wall of reporters waiting, it became clear. This was no longer just a courtroom matter. It was about to become a national conversation. The next morning. The gallery filled before the doors even opened. Reporters arrived 2 hours early, gripping microphones like weapons, scanning the parking lot for any sign of him. Some spectators had driven in from neighboring towns, just to witness it firsthand. Every seat was claimed. Even Judge Colton's bailiff had to remind the crowd, this was a federal hearing, not a spectacle. Musk entered the courtroom the same way he had the day before, quietly, wearing the same suit, the same composed expression. But something had shifted. He wasn't just a billionaire anymore. He was the man who had stepped into a courtroom and, through sheer force of logic and restraint, made a federal judge think twice. The prosecution's table had grown overnight. Now 3 attorneys sat there, 2 from the original team, plus a new face from the Office of Special Counsel. That alone spoke volumes. At 10:02 a.m., Judge Colton entered. "I've reviewed the materials presented yesterday," she began, "and I've conferred with a panel of legal advisors from within the district." That landed like a weight in the room. Judges didn't do that unless something deeply uncomfortable had surfaced. "Elon Musk's statements," she continued, "did violate the spirit of courtroom protocol, particularly in preserving confidentiality. However, the penalty initially assigned may have exceeded the authority granted under Section 35B. A pause. A murmur rippled through the gallery. She turned her attention to Musk. Your reading of the exception clause and reference to Stansfield were accurate. And while this court does not take overturning its own penalties lightly, the fine will be reduced from $3.2 million to a symbolic $25,000. This acknowledges both the violation and the legal argument that tempered it. No one clapped. But the shift in the room was palpable. Elon didn't smile. He didn't nod. He simply said, "Thank you." "Your Honor." The judge raised a hand, cutting him off. "I'm not finished." The courtroom hushed. "I want to make something clear," Judge Colton continued. "This court is not reconsidering its decision because of your wealth or public status. You earned this adjustment because you came in prepared, respectful, and precise. That doesn't happen often. But it matters." A woman seated behind Musk leaned toward her husband and whispered, "I thought he'd be arrogant." She shook, her head slightly. "He's not. He's just different." The judge closed her binder. Court is adjourned. People stood. Reporters bolted for the exits, eager to file their stories. But Musk remained seated for a moment longer, watching, as the judge stepped down. Then without a word he rose, walked past the now silent gallery, and exited through the same door he had entered. But outside those walls, the world was already rewriting the moment. Headlines appeared within minutes. Elon Musk challenges court. Fine, walks away with a win. Judge revises ruling after Musk's self-defense shakes the room. One man, no lawyers, just a whole lot of case law. Pundits scrambled to debate. Was this an example of legal genius, or just another case of the rich bending the system? Had Musk exposed a flaw in the courts, or had he simply wielded truth more effectively than most? Some speculated it was a calculated spectacle, designed to rally public sympathy. Others believed the opposite, that he had been fully prepared to lose and had spoken simply because it was right. But one thing was undeniable. People hadn't just read about it. They hadn't just seen a headline or a tweet. They had watched it happen. A man stood in a courtroom, challenged the very system trying to penalize him, and made it think twice. Not with money, not with force, but with words. And as the noise outside grew louder, one thing became clear. This wasn't just about a fine anymore. It was about to become a national reckoning. That same afternoon, Judge Deirdre Colton sat alone in her chambers, staring at a legal pad filled with annotations she never expected to write. A cup of coffee sat untouched, long gone cold. Her clerk had stepped out. Her phone buzzed with missed calls from old colleagues, journalists, and law professors. She ignored them all. Instead, she looked down at the words she had underlined in her own handwriting. He wasn't wrong, not entirely. Colton had seen controversy before. In 26 years on the bench, she had ruled on racketeering cases, class action lawsuits against pharmaceutical giants, and civil rights disputes that made national headlines. But she had never encountered someone like Musk, someone who walked into her courtroom, spoke plainly, and dismantled a multi-million-dollar penalty using nothing but footnotes and federal precedent. And what gnawed at her wasn't that she had reduced the fine. It was that he had forced her to admit the court had possibly overreached. She pulled up the ruling again. Section 35B, Exception Clause. Whistleblower intent. There it was, clear, unambiguous, buried on page 4, exactly where he said it would be. She scribbled a note in the margin. We missed this. Why? A knock at the door pulled her from her thoughts. Her clerk entered, a slim folder in hand. Judge, the Office of Legal Oversight called. They want a brief on the Musk adjustment by Friday. She exhaled through her nose. And Channel 12 is asking for a statement. No press, she said immediately. He hesitated. There's more. She raised an eyebrow. Law students at UC Davis are circulating the transcript. Professors are assigning it for legal ethics discussions. He swallowed. It's turning into a thing. Colton narrowed her eyes. A thing. He nodded. They're calling it the Fresno defense, like when a defendant flips a courtroom. using the system's own tools. For a split second she almost laughed, but she didn't. Instead, she simply said, "Close the door." It clicked shut. She turned back to her screen, scrolling through the raw transcript of the hearing. Musk's words stood out like highlighted passages in a textbook, calm, logical, strategically placed. One line made her stop. If a court can issue unlimited fines for statements that weren't explicitly covered by the gag order, then where does that discretion end? Where is the limit? That one stuck, because it wasn't just a defense. It was a question no judge wanted to answer. Across town, in a quiet cafe off Ashland Avenue, Elon Musk sat by the window, watching the street. His assistant murmured into a phone nearby, handling the media requests he had no intention of accepting. He wasn't celebrating. He wasn't giving interviews, he was just thinking. A woman in her late 50s approached hesitantly, a to-go coffee in hand. "Excuse me," she said softly. He looked up. "I just wanted to say..." She paused, searching for the words. "I don't know if I agree with everything you said in there." A small smile flickered. "But I watched it online and it mattered." Musk nodded once, expression unreadable. "Good." Then, as she walked away, he turned back to the window. Outside, the world was still arguing over what had happened, but inside, he already knew. This wasn't over. Not by a long shot. "The way you carried yourself in there," she said softly. "It mattered." Musk looked up, surprised. "Thank you," he replied simply. She gave a small, knowing smile, nodded once, and walked away. No applause, no spectacle, just a quiet exchange, a moment. That meant something. Back at the courthouse, Judge Colton reopened a private memo from the district's legal review board. Her eyes lingered on the final paragraph. While the reduction in penalty was unexpected, it demonstrates the court's ability to recognize its own limitations in the face of well-founded legal arguments. This is not a sign of weakness, but a testament to judicial integrity. She exhaled slowly, allowing herself for the first time that day to breathe a little easier. But if one courtroom could be shaken like this, what would happen when the broader legal system took notice? By the next morning, it wasn't just legal analysts and headline writers buzzing. It was everyday people. Uber drivers debated it between rides. Barbershops in Fresno and Bakersfield tossed around terms like gag order and whistleblower clause as if they were breaking down a playoff game. On a late-night AM radio station in Modesto, a caller admitted, "I don't even like the guy, but what he did in that courtroom, that was something else." Cable news scrambled to book constitutional experts. Clips of Musk's courtroom appearance flooded social media, not because he had been theatrical, but because he hadn't. No dramatic outbursts, no table slamming, just a man calmly dissecting a penalty he believed was unjust. And somehow that was more captivating than any scripted legal drama. One national morning show aired a side-by-side comparison, Musk's transcript against Judge Colton's revised ruling. A former federal prosecutor shook his head on live television. He played the long game. He anticipated the counterarguments before they even arrived. The phrase Fresno defense started appearing in op-eds and law journals. Editorial boards began asking uncomfortable questions. How often did courts issue fines without fully acknowledging legal exceptions? How many people had simply paid because they lacked the time, the resources, or the nerve to push back? Suddenly, Musk wasn't just a billionaire. He had become a symbol of something people hadn't realized they craved, proof that the system could still be challenged, that sometimes it could bend, if you knew how. Not everyone saw it that way. At the Department of Justice, an internal memo warned federal judges of the precedent this might set. While Musk's approach was unconventional, his arguments, if not properly rebutted, could encourage more high-profile figures to self-represent, potentially disrupting courtroom proceedings. A columnist in a San Francisco newspaper called it dangerous. "We cannot afford to romanticize courtroom gotcha moments, not even when they come from a man with a 12-0 net worth. The law isn't a game." Others pushed back. A retired judge from Sacramento wrote in an op-ed, Elon Musk didn't challenge the law, he used it. He reminded both the public and the judiciary that no system is too powerful to be questioned. That's not rebellion. That's democracy functioning as it should. Even skeptics couldn't ignore the impact. At a law school in Los Angeles, Professor Joanna Menendez opened her civil procedure class by projecting Musk's transcript onto the board. Like him or not, she told her students, this is how you speak when you've read every line twice. This is how you walk into a room where the odds are stacked against you and say, here's what you missed. Back in Fresno, Musk remained quiet. No press tour, no victory lap, just business as usual. But his staff noticed something different. In meetings, people greeted him with more curiosity, spoke with more caution. One engineer from one of his subsidiaries finally asked, "Were you nervous in there?" "Yes," Musk admitted. "Did it show?" "I don't think it mattered, because in the end, the fear hadn't stopped him from standing up and speaking. He hadn't overpowered the court. He hadn't won on a loophole. He had simply followed the rules more carefully than anyone expected, and that's what lingered. Not the fine, not the headlines, but the idea that maybe, just maybe, knowing the system could be as powerful as challenging it. Yet while Musk moved on, the system he had confronted couldn't quite shake the moment. The ripples were just beginning to reach the surface. Weeks later, long after the news cycle had moved on, the case still echoed in quiet corners of power. Judges referenced it in private discussions. Law firms updated their training modules. And across the country, in classrooms and courtrooms alike, people kept returning to the same question, one the system wasn't quite ready to answer. What happens when someone who truly understands the rules decides to play by them better than anyone else? Professors continued to slip Musk's arguments into PowerPoint slides under a new heading, when the defendant pushes back. But the biggest impact wasn't in institutions, it was in people. Marcus Albright, a 34-year-old mechanic from Flagstaff, had never followed a courtroom story before, but one night he stumbled across a clip from the hearing on YouTube. 6 minutes of Elon Musk speaking, nothing in front of him but a single sheet of paper. No smugness, no theatrics, just a man making a point no one could ignore. Marcus didn't care much for billionaires, but he watched that clip twice. Then he printed the transcript and brought it to work. His co-worker frowned. "Why would you print that?" Marcus shrugged. "Because if a guy like that can walk into a courtroom and stand his ground without hiding behind 30 lawyers, maybe I can speak up at my next union meeting, without second-guessing every word." In Sacramento, a 62-year-old retiree named Barbara Levis filed a motion to revisit an old fine from a housing code violation she believed had been mishandled. She referenced Musk's case in her hearing. To her surprise, the court clerk recognized her appeal wasn't overturned, but it was reviewed, and she got a partial refund. The takeaway wasn't that Elon Musk had outsmarted the system. It was that the system, when met with reason and calm defiance, could still pause, reassess, and acknowledge its own missteps. That's what stuck. Inside the courtroom, Judge Deirdre Colton's decision had nothing to do with admiration. It wasn't personal, it was structural. The facts stood, the argument made sense, and once she saw it clearly, she did what her position demanded. She corrected course. But outside the courtroom, it didn't feel procedural. It felt like something else, a moment where accountability stopped being a one-way street. Weeks later, a podcast host posed a simple but pointed question. Was this about power or precision? Her guest, a legal analyst, paused before answering. Precision is power, it's just quieter. And maybe that was the lesson. We're used to thinking influence comes with noise, with drama, with spectacle. But this story showed something else. That it's still possible to challenge authority with a straight back, clear words, and the law in your hand. It reminded people, no matter their background, that standing your ground is sometimes more valuable than any title or name behind you. Because when you're right, and you know why you're right, even a federal courtroom has to listen. At the end of the day, Elon Musk didn't walk out a hero. He didn't walk out a villain either. He walked out as a man who knew what the rules said, and made sure everyone else did too. And in an era where noise often drowns out truth, maybe that's exactly the kind of quiet power we need more of. So here's the takeaway. Don't assume every system is immovable. Don't back down just because the room feels bigger than you. Read every line, know what you're standing on, and speak. Because even the loudest voices in the room can be silenced by one person with the right words and the courage to use them. If this story moved you, made you think, or reminded you that logic still matters, subscribe to the channel. We have more stories coming, ones that challenge, inspire, and stay with you long after the screen goes dark.